Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about the bankruptcy discharge of debts and the facts. Look, in the bankruptcy code, there are specific reasons why a debt that you incur may not be discharged in the bankruptcy proceeding. And there's a certain classification of debts that just don't get discharged. Nobody has to say anything. It's self-effectuating. So, for example, child support, student loans, taxes. The general rule is they're not dischargeable. There's exceptions to this. But then there's a certain classification of debts that unless a creditor objects to you discharging it, it is discharged. In other words, the creditor has to go first. They have to say, no, you cannot discharge this debt. One of them is for willful and malicious injury by the debtor to somebody else. And so, this gets into a fact-intensive analysis. If you're in a bar fight and you injure somebody and cause damages, was it the damages willful and malicious? And it might have been willful, but is it malicious? In other words, were you defending your wife? Were you defending yourself? Were you a child? Et cetera, et cetera. It's very fact intensive. And in my 27-year career, I've seen very few of these cases brought. When the time is right, when you are ready to get your life back, reach out to Lifeback Law Firm. You're going to be so thankful you did, and consider hitting the subscribe button.